Here are all these mechanisms which are supposed to protect the average Joe. And what we've seen here in a critical situation, because the election of the president is obviously a critical situation. In this critical situation, all of the checks and balances have failed. And the people who are now going to be in control, apparently, they're telling us that anyone who criticizes this is somehow a bad actor. And their allies in the social tech world and the corporate world are telling us that you're not going to be able to speak, at least on these various platforms. We're going to shut you down. The point is we've gone that full step. The government has failed. These structures have been set up to control thought and belief, and apparently there's no way that the government is going to control them, and then the average person has no recourse.
This is Donegan Kaiser, founder of Liberty and Finance. I'm now a licensed gold and silver dealer with Miles Franklin. Call me directly for the physical gold and silver that you need at the best price with personalized, private service from one of the oldest and best respected companies in the business. 30 years strong, A+ rated by the Better Business Bureau, 0 complaints, licensed and bonded, insured delivery or vault storage or IRAs, excellent prices, privacy and confidentiality, pay by check, money order, ACH or wire, satisfaction guaranteed. Call me directly at 419-819-9209 or my associate at 310-562-6400 or email us at kaiser@milesfranklin.com. Welcome back to Liberty and Finance. We have a returning guest today. Dr. Edwin Vieira is a constitutional attorney. He has been with us several times in the past. He's well requested by our subscribers because he brings a very studied and informed view of the constitutionality or lack thereof in our public policy and our public lives, but also the true intention and the basis that our Constitution does provide to give us insight into what our country was founded to uphold, and helps us to find out what we need to do when we go off the rails as a country. Dr. Vieira, thank you for joining us again here on Liberty and Finance.
It's my pleasure.
We've been stunned by the rapidity of just all kinds of events that have been occurring in the past month or so here at the beginning of 2021, and wanting your perspective as we look at these things unfolding. One of the things that you and I were just talking about was how it appears that we're no longer using the U.S. Constitution as our playbook or our guideline in making many of these official decisions that are being made that are affecting people's lives, and both individually, their ability to exercise free speech, our ability to gather, our ability to protest for the redress of wrongs, and then also just to be heard. You joined us in December talking about the outcome of the presidential election and what needed to be done to bring truth to that and to bring proper perspective on how that needs to be handled. As you look at these events that are unfolding right now, many people are just bewildered. We don't know which end is up, what's going to come next, what the next week, month, or year is going to look like for us. What are some of the specific examples that rise to the top of the heap in your mind of non-constitutional or unconstitutional actions, policies, behaviors, developments that have happened that people should be aware of? And then we'll get into what we can do about it.
Well, first let's try to distinguish constitutional form from constitutional substance. We have quite a few activities that have gone on in the last few months that purport to take a constitutional form. And I could go and look particularly at the presidential election, look more recently the other day at the impeachment resolution put up by the House of Representatives. Those things appear in the guise of constitutional action. And the problem we have in this country as a generality is that a vast majority of people don't recognize that the form of an activity does not necessarily justify that activity substantively. That is, you can have Congress, a classic example, of course, Congress passing some statute. They do it in the proper form. The president signs it. The statute is unconstitutional nonetheless because the substance of it is contrary to constitutional principles, especially constitutional limitations. So when we look at a number of these actions that have occurred recently, and I could go back all the way to the various riots that were taking place in Portland and Seattle, Minneapolis, Atlanta, whatever, and we look at the way public officials, both at the state and the federal level, have responded to this in the form of constitutional activity. Right? They pay lip service to the Constitution, but the substance is never actually enforced. So let's take the example of the election. Most people don't realize that constitutionally no one has a right to vote for the President of the United States. No individual has a constitutional right to vote for the President of the United States. The selection of electors is left by the Constitution to the state legislatures, not the state governors, not the state courts, but the state legislatures alone, which determine the manner in which the electors will be designated. So that could be the legislature providing for a plebiscite of some kind, as most states now actually do, or the legislature could directly appoint the electors or appoint some committee that would select electors. It's a potentially infinite number of possibilities. And there's a famous case, well, famous to lawyers, I suppose, called McPherson versus Blacker, which is in volume 146 of the United States Reports, if anyone wants to look this up, where the Supreme Court goes into great detail, historical analysis of how electors were selected in various ways from the beginning of the country through, well, it's 1892 when the case was decided. So if we look at this situation, we say, all right, many of these so-called swing states, the legislatures had provided for plebiscites, that is, elections in which the average citizen had a statutory right to vote. But those plebiscites were not conducted for one reason or another in a constitutional fashion, because obviously the constitutional fashion is that you have to have eligible votes counted, ineligible votes not counted, and some method for verifying or falsifying, scientific analysis, if you will, that the plebiscite has done what it's supposed to do, which is to give you an accurate tally of the people voting for one candidate or another. So there are all sorts of things that happen. Pennsylvania is a classic example, I suppose, where the legislature had not provided for mail-in ballots. And I guess it was Secretary of State and the governor, maybe both of them, said, oh, you can have mail-in ballots. And then the Supreme Court of Pennsylvania said you could have mail-in ballots. Well, all those decisions by the executive and the courts in Pennsylvania were clearly unconstitutional. The legislature decides the manner of choosing electors, and it cannot be changed by judicial opinion, cannot be changed by executive action. So if you look at just that state alone, you'd say, well, we have a serious constitutional problem. Where would that problem be resolved? Well, it could be resolved in the state legislature directly. The state legislature could simply come in and say, we've designated this method, and we're not going to accept electors that have been selected by this other method that the executive and the judiciary seems to want, and we're going to provide our own slate of electors. Well, they didn't do that because the normal course of events was followed here, although this was an abnormal situation, and people took the issues to court. And let's just focus on one of those cases, the one that was submitted to the original jurisdiction of the Supreme Court, Texas versus Pennsylvania, Georgia, Michigan, Wisconsin, that group of swing states. Now, there was a classic example of I won't go beyond the word fail, let's just say failure of the judiciary to perform its function. So once again, we see the form. The Supreme Court says, well, we're not going to take this case because it's what they say non-justiciable. There's no standing for Texas. But the substance is completely false. And I can tell you that very clearly because if you look at the Electoral College system, it is a system in which the states are the actors, not the average citizen. Mm-hmm. As I said before, the average citizen has no constitutional right whatsoever to vote for a president of the United States. It depends upon the method that the state legislature chooses. So the state legislatures choose the electors. They provide a method for choosing the electors. The electors then go to the so-called Electoral College, although they all meet in their own states, but to certify the ballots. And that Electoral College is an institution of the states. Those electors are agents of the states for the purpose of coordinating the vote tally on behalf of the states. Right. So if anyone has a claim to question the regularity of an election or other procedure in a state that resulted in certain electors being sent to the Electoral College. Other states have that standing, to use the correct term. Other states have this direct interest in what happens in the Electoral College because it is a state-centered institution. So the Supreme Court said, no, that isn't, we're not going to listen to that case brought by Texas against Pennsylvania. They wrote no opinion, of course, because they couldn't write an opinion. All right? I can't imagine they could write an opinion. Any lawyer in the United States, constitutional lawyer in the United States, would have looked at it and said, oh, yes, that's correct. They just, as the expression went, punted. Well, now we have a situation where potentially fraud, I'm not going to say they were necessarily fraudulent, they were irregular elections in those swing states. There might have been fraud, there might just have been mistake and incompetence, whatever, doesn't matter. There were irregular elections in those states. Wrong electors, arguably wrong electors, were selected in at least 5 or 6 of those states. They went to the Electoral College, cast irregular votes, and as a result of those irregular votes, it is arguable that a president and a vice president will be inaugurated on the 20th of January who are not in fact qualified under the Constitution of the United States to hold those offices. So they will be usurpers, from which it would follow that every action they take in a so-called official capacity would not be an official action at all. It would be illegal. So you think of the chaos that could be caused if a year from now some case finally decides that there was electoral fraud. Let's make that make it the worst possible case, and that Mr. Biden and Ms. Harris were not really qualified to be president of the United States. And now we suddenly realize, a year's worth of presidential action, signing legislation, writing executive orders, perhaps negotiating treaties, whatever, all the things that the executive branch can do. All of that is unconstitutional, illegal, without effect, has to be set aside. Think of the chaos. And you can imagine that no court would ever entertain a lawsuit, or they try to dodge any lawsuit that might result in forcing that chaos on the country. So now you have generated the principle that people can be illegally elected to the highest office in the land, and that as a practical matter, probably nothing can be done about that because once they get into the practical aspect of that office, leave aside the legality of it, no court will interfere because it will be too frightening to try to overturn actions that are taken at that level of government. So that's principle number one. And what that tells you, and there were a number of cases. So some people say there was as many as 60 cases. I haven't seen 60, but I didn't necessarily look for every one of them, that refused to hear these challenges to the various elections in various states. And not on the basis that they actually held trials at which the facts were presented according to the rules of evidence, and juries, or maybe judges, because you have a judge trial as well as jury trial, decided what the facts were, whether irregularities, was there fraud, whatever it might be. None of that was done. They dismissed all of these cases at the very onset. Now that, to me, who did a lot of litigation in my life, is that's not simply a statistical impossibility. It's an impossibility. Because what actually happens when a court case is filed, civil case, and we're not talking about criminal cases, civil case is filed, the plaintiff files a complaint and makes certain allegations. And these are statements of fact that the plaintiff believes are true, such as Jones was seen by Smith breaking a window in somebody's house. That might be true, it might not be true. But at that stage, what the judge has to do is to treat those allegations as true and to decide if they are true, does the plaintiff prevail as a matter of the law? Okay? Can Smith sue Jones on the basis of the allegation that someone saw Smith smashing Jones's window? And the answer to that question would be yes. Now, in the trial, it might turn out that the person who purported to see Jones had very bad eyesight. He had never seen Jones before. He couldn't even recognize him in court. And therefore, the plaintiff would lose his case after the evidence had been presented to the jury, and the jury had decided what the facts really were. All right? Now, that never happened in any of these cases. Think about the significance of that. There wasn't a single judge, as far as I know, who was willing to say, oh, yes, We have to allow these facts to be determined by the normal course of judicial procedure. We can't simply dismiss a complaint based on some legal technicality. Well, all laws are legal technicalities in a sense. Standing, ripeness, mootness, latches, whatever, these various avoidance techniques that the courts use to evade having to decide the issues on the merits. Sometimes those things are legitimate, but sometimes they're not. And I would venture that in these cases, the vast majority of them, it was not the case, the situation, that those avoidance techniques were justifiable. Now, there may be some, because some complaints may have been inartfully drafted, or maybe they couldn't make a particular allegation. I would assume that in most of these situations you had to make an allegation saying that the result of the election would have been different if certain irregularities hadn't been allowed for, or whatever. And maybe they didn't plead that properly. So there are some possibilities that some of those cases would have been legitimately dismissed at that stage. But normally what happens then is the plaintiff files an amended complaint. The court tells them, well, we're going to dismiss this case because what you put in your original complaint was no good, and then on the basis of what the court has said, the plaintiff comes back with an amendment and says, now I've corrected that. That's typically what happens. But you look at the Supreme Court case, they refused to exercise their original jurisdiction. And that's a little bit tricky. Let me explain that. The Supreme Court can hear certain cases directly. In the normal course of events, case arises in a trial court, goes to an appeals court, and the loser files a petition with the Supreme Court. So the Supreme Court is an appellate court. It hears the case on appeal. It's not a trial court. Original jurisdiction is when the Supreme Court acts as a trial court. The case starts and ends in the Supreme Court because there is no higher court. And there are certain circumstances in which that jurisdiction attaches. And one of them is where a state is a party. Okay, you have to have a state on one side. Well, in the Texas versus Pennsylvania case, you have states on both sides. Texas was suing other states. And Texas clearly had a claim that its electors in the Electoral College were being negated. The force of their votes, the effect of their votes was being negated because there were false electors on the other side which had come from these other states. So you clearly had, first, original jurisdiction, and secondly, you had a claim that could be heard in the original jurisdiction. And Texas obviously had an injury to the state itself, not simply its people, but to the state itself, because the state's electors, the electors being agents of the state, they had their votes negated, diluted, whatever, canceled by the false votes on the other side. So you look at what the Supreme Court did. The Supreme Court refused to exercise even its original jurisdiction. It said, we're not even going to let this case in the door so that we can look at the complaint. And there were only two people who dissented from that, Alito and Thomas. And unfortunately, they didn't write an opinion as to why they dissented. I could write one for them. But they didn't. So you look at that and you say, well, the entire judicial system has now been demonstrated to be impotent, compromised politically, whatever word you want to say. Why, in particular instances, that happened, I don't know, but it doesn't make any difference to me. The system has now, at least these people who are in the system, has now been demonstrated to be ineffective in the sense that it was put in the first place, which is to maintain constitutional principles in the action of the political process and governmental process. So now that would then tell you that we are in a state of lawlessness, because according to the way the system normally works, issues go into the judicial system, and the courts decide them according to facts that are proven and legal principles that exist in statutes and constitutional provisions. Now, here we've been told, no, that's not going to happen. When we have a fraudulent election, an arguably fraudulent election, where there were, by the way, literally hundreds of sworn statements.
True.
All right? And let me just add to what I said before. When you file a complaint, typically, in a civil case, you make allegations. You don't file sworn statements as appendices to your complaint. That is very rarely done. In all the time that I ever litigated, I only did that once, and that was because We were challenging the application of a rule of a federal agency, and that rule had been involved in a number of other cases which had supported the federal agency. But those other cases hadn't gone into a certain aspect of the problem. So we had to tell the court, we understand that there are all these cases against us, but they didn't decide this particular issue. And we have attached to our complaint an affidavit from an expert who has gone into this problem to show you that we're not just filing some kind of frivolous case.
Right.
And that's because we had all of these other precedents against us. So that was a very odd situation. That certainly was not what happened in any of these voting fraud cases. None of them. So it was unnecessary for all of that sworn testimony to be appended, but it was appended anyway. And that makes the situation even worse. Because as I said before, when you file a complaint, you write allegations. Those allegations are just statements that the lawyers make, basically, in the complaint. And there's really no evidence attached to the complaint. And the judges are simply supposed to treat those allegations as if they were evidence and then say, if this, then that type of thing. And we'll go forward and find out what the truth is when we have a trial. So these complaints, or at least a large number of them, especially the one Sidney Powell filed, were far in excess of what was necessary to get a case heard. And I would say even the Texas case was similar because there were a lot of paperwork that went in besides the initial motion to have the court hear the case. And so if you read all that stuff, I mean, it's thick. It's 6 inches deep from both sides. All this paperwork that went in. You see the case was a clear cut one that the court should have taken and decided. So why didn't they do it? I don't know. There are all sorts of stories. But the bottom line is, okay, now you can have a presidential election conducted with all sorts of irregularity, including fraud and possible involvement of foreign actors, which makes it even worse, maybe a national security issue here. And the entire judicial system will look the other way, where the consequence is that you may put a person in the position of President of the United States who is an usurper, who was not legitimately elected. Well, that's bad enough. But then you look at someone like Miss Harris, there's an interesting question as to whether she's even qualified to be vice president. Her parents the mother was from India, the father, I believe, was from Jamaica. Neither one of them was an American citizen when she was born. She may have been born in the United States, but that makes her only a citizen, not a natural-born citizen. Natural-born citizen has to have both parents be American citizens. She had neither parent be American citizen. There's some dispute about that, whether it could be just one parent or both parents. But she had neither. All right, so this person is not qualified to be vice president, which would mean she's not qualified to take over the presidency when Mr. Biden finally goes into the old folks' home. So now you think of the consequences of this. It's just fantastic. Now let's go to the next step, which is an impeachment that happened the other day. And the impeachment was based upon statements that President Trump made when he addressed the crowd of people that was assembling in Washington. And they say, well, these statements were incitement to violence. Okay, and maybe the sedition, God knows, use whatever words they want to use, incitement to violence. Well, it was a statement that is the basis of the charge. So that implicates immediately the First Amendment of the Constitution of the United States. And First Amendment starts off, Congress shall make no law. Well, an impeachment resolution is, in fact, a kind of law. All right? Certainly it's made pursuant to the powers of the House of Representatives under the Constitution. So there's the law that they have enacted, this impeachment resolution. And it's predicated upon statements, on speech. And speech that is supposedly intended by Trump to foment some sort of insurrectionary act, incitement to violence, whatever terminology you want to use. Well, there's a famous Supreme Court case, and it's famous to lawyers, I guess, Brandenburg versus Ohio, decided in 1969, which goes into this specific question. When can speech be used as evidence for a prosecution, and it would particularly in the context of incitement to violence? And the Supreme Court said, oh, it can only be used when the speech is directed to imminent violent activity. That is where the speaker says, let's pick up our torches and go and burn down the state capitol right now. Let's do that. As opposed to saying, the people in the state capitol are so bad that someday someone may, a mob may go and burn the capitol down. Right? Some kind of prediction of the future as opposed to immediate incitement to action. Well, if you applied Brandenburg versus Ohio to what I have seen that Trump said, I wasn't through all, through everything he said, but what they're claiming is the basis for this impeachment. It's nonsense. Absolute nonsense on the face of it. So what are we talking about? Well, the impeachment is bogus. The conviction, if there were a conviction, the trial would be bogus. If there were a conviction, that would all be bogus. So now we come back to the House of Representatives, the members of the House of Representatives who voted for this thing. Do they ever read the First Amendment? Congress shall make no law, etc., speech, religion, free press, petition, right? They never read that. Many of them are lawyers. Mm-hmm. Are they not aware of Brandenburg versus Ohio? A very famous case. So we have a House of Representatives, at least that group, but don't care about the Constitution. So there's a form that they're following. They go through the motions of the impeachment process, but the substance of it is completely bogus. And it's bogus beyond the point of, well, they simply made a mistake. No one makes mistakes like that. If they do, they're certainly disqualified to be in any public office, let alone the House of Representatives. So we can say, okay, the courts are totally compromised. They've demonstrated they don't intend to stand up for the Constitution, even to investigate a question, because obviously they could have held trials and ruled against the plaintiffs in all those cases after the trials were held. Said, well, the evidence doesn't support the relief required. You haven't proven fraud. You haven't proven irregular after the trial. So, but they didn't even want to hear it. Mm-hmm. And now here we have the House of Representatives purporting to exercise its impeachment power on the basis that a first-year law student would tell them is improper. So the House of Representatives and the courts have now both proven themselves to be outside of the boundaries, the substantive boundaries of the Constitution, notwithstanding they may be operating under the forms. Well, whom does that leave? Well, I guess that leaves the executive branch,
right,
which is Trump. And all I can say about Trump is, and the people around him, because a lot of people have failed him. You take Barr, the Attorney General, who claimed he didn't see any evidence of fraud in the election. Is he a blind man? We're talking about hundreds, literally hundreds of affidavits from people, sworn statements, many of them made by experts who dealt with the computer aspect of the problem, who were coming out and saying, well, this was statistically impossible that certain things happen. That's not evidence? Well, it certainly is evidence at the basic level, gets you into court. That's sufficient evidence to get you into court. Maybe a jury wouldn't believe it later on at the trial, but it gets you into court. And the Attorney General of the United States, supposedly one of the top lawyers in the country, he didn't see that there was some evidence there that might merit an actual trial? Please. Well, that was Barr. All right. So Trump has been proven not to be able to rely upon his own people. But, of course, he picked them, so I guess he's at fault there. And when Texas brought its lawsuit, I was surprised that Trump didn't get somebody in the Department of Justice. Probably wouldn't have been Barr, but he'd get somebody else. Solicitor General, perhaps, to file a lawsuit, intervene, actually would have been the thing to do, to intervene in the Texas case on behalf of the United States. The case should have been United States versus Pennsylvania, Georgia, Michigan, Wisconsin, whatever. Because who has the primary interest in the identity of the President of the United States, having the right person in that position? Well, it's the United States. This is the President of the United States, right? Just like it would be the corporation itself that has the interest in whether its CEO has been properly elected by the board of directors. So the United States should have been one of the plaintiffs in that Texas lawsuit. I'm surprised that he didn't do that. And somebody advised him to intervene on his own behalf, Donald Trump, coming into that lawsuit. Well, he would also be a person who had standing because he's the president, and the fraud in the election was directed at him to prevent him from being reelected. He has all sorts of personal civil rights involved there. But the real plaintiff should have been the United States of America versus these states. So who was giving him advice? He had bad advisors. And to a certain extent, I blame that on Trump personally, because he's responsible for choosing those people.
Mm-hmm.
And you saw in the executive branch a lot of, which I could say, confusion. You had Sidney Powell. Sometimes she was there at the press conferences as if she was part of the Trump legal team. Sometimes she was not. Sometimes they said she was. Sometimes they said she wasn't. Back and forth, up and down. So you look at that, I look at that, and I said, well, these people, they didn't know which end was up.
Mm-hmm.
They had no coherent strategy. And I especially say that with respect to Sidney Powell, because what's the history there? In the Flynn case, everyone in the executive branch, everyone, including Trump himself, accepted the proposition that Flynn was guilty of some criminal violation, including Flynn's own lawyers, original lawyers, because they recommended to him what he did was take a plea bargain, basically. Sidney Powell comes in way after the fact, and what does she do? She does the thing that any criminal attorney would do at the beginning of the case, which is to ask the prosecution for what's called Brady material. Brady versus Maryland was a Supreme Court case that held that the prosecutors have a constitutional duty to turn over any evidence they may have that could be exculpatory, could tend to prove the innocence, the absence of guilt of the people that they're prosecuting. So she asks the Department of Justice, an obvious thing that should have been done long ago. The Department of Justice starts turning over this information, and we all know what happened. It was proven that Flynn was a victim of a frame-up. And eventually the Department of Justice was so embarrassed by this, under Barr, that they had to come in and ask Sullivan, the judge, to dismiss the case. And then Sullivan went on this rampage of his own, this vendetta he had against Sidney Powell and Flynn, which was stopped only by Trump giving Flynn a pardon, which in a sense was unfortunate, because if Flynn was, as I think, not guilty of anything, then he didn't need a pardon. He should have had that case dismissed. But in any event, you look at even that situation and the disarray, disorganization, dysfunctionality of the executive branch. And that was because there are all sorts of dissensions built into that part of the government, so-called deep state proposition. Right? So I look at all this and I say, well, what do we have now? Well, we have this form called the Constitution and Laws of the United States. And then we have every branch of government, because I don't expect the Biden-Harris administration or the Harris-Biden administration, which will really be, that the Harris-Biden administration is going to be any more organized than the Trump administration. There are all sorts of dissensions within the Democratic Party, which will cause that not to, coalesce into a monolithic operation. So every branch of the federal government is compromised now, in substance. And I go and look at the states as well. All the states are compromised, because some of these cases came out of state courts. Mm-hmm. In the swing states, the legislatures could have taken action. I think in all the swing states, the legislatures were Republican. So just as partisan, political impetus would have led them to do something if those legislatures had actually wanted to follow their constitutional duty and authority, exercise that authority. So we look at that and say, okay, the state courts are bad, the state legislatures are bad. In many of those states, it was the state executives that changed or manipulated the electoral process illegally. So the state executives are bad. So things rotten at both levels of the federal system. The national government of the United States is in form fine, in substance rotten. The state governments in these important states, at least, and probably in others, but certainly in these important states, in form are fine, in substance are rotten. Well, where does that leave us? Jane and Joe Dokes. Well, I don't know. In substance, we really don't have constitutional government anymore. The form is there, but the substance isn't. So where are you now? This is lawlessness. The concept of law has been lost here. Not just the practice of law, but the very concept. The idea that these people have to respond not simply to the form, but to the substance. And they laugh at that. That's why I take the impeachment thing as an example. Sure, it was partisan political. Democrats versus, well, Trump. I don't know, because a lot of Republicans apparently sided with the Democrats, too. Sure, it was partisan political. And so you can expect a certain amount of partisan political bias to inject itself into the system. But there's a limitation to that. When they cross the yellow line to the wrong side of the law, that has to stop. Well, these people no longer consider that crossing to the wrong side of the yellow line has any significance. They just do it. And if they would do it to Trump, President of the United States, out in the open, with such a completely asinine theory, what will they do to you and me? And the answer is, well, anything they can get away with, which is essentially anything, because we certainly don't have the ability of Trump to fight back against them within the governmental system. I'm surprised that he didn't simply come out and say, right at the beginning, you can file all the impeachment resolutions you want, but if you're going to go on the basis of speech, and the speech that I, Trump, made, it'll be in violation of Brandenburg versus Ohio. It's illegal. It's unconstitutional. I don't intend to pay it any attention whatsoever. Now, he didn't say that. Why? I don't know. He said, I'm not his lawyer. I would have told him to say that. And he's just arguing political points with them. Oh, this is the Democrats coming at me because they hate me and so forth. So who cares about that? We know that's true, but that's not the consequential matter. So now where are we? Well, the answer is we're in a very dark period. Because we've already seen what the... what shall I say, the myrmidons of the Democratic Party, big tech, and the big corporations are doing to stifle any form of dissent from the Biden-Harris or the Democratic Party program, whatever that may be. Especially this concept that somehow it's illegitimate for anyone to go onto social platforms or YouTube or whatever, these various outlets, and talk about the possible irregularity or fraudulence of the election. That strikes me as incredible. That anyone would even... And, of course, they're shutting people down who are doing it.
Yep.
They shut Trump down. Now, I wondered about Trump because, as far as I know, and I don't follow Twitter and Zuckerberg's operation or any of those other things. They're all nonsense. I thought they were nonsense when they started. They're nonsense now. But as I understand it, Trump had 3 Twitter accounts. One was his personal account. And then the other 2 were somehow connected to the government. One was whitehouse.gov, and the other was POTUS. Whatever. And Twitter shut them all down. Now, as far as his personal account, Twitter says, well, we're a corporation, we can do whatever the hell we want. Okay. But these other 2 accounts were governmental accounts. They weren't personal to Trump. And so one wonders whether that was a direct interference by Twitter, Facebook, whatever, sorry, Twitter in this particular case, with the ability of the government of the United States, through Trump, the President of the United States, to communicate with the people of the United States on official business.
Mm-hmm.
Oh, now what do we have there? That's very interesting, that one. Imagine if we were back in the 1930s and Franklin Roosevelt was giving his famous fireside chats on the radio. And you had CBS, NBC, it was ABC there, Westinghouse Broadcasting. There were 4 or 5 radio channels. And you'd see Roosevelt picks up in front of a bank of microphones. Now, what if they were private corporations, right? Subject to FCC regulation, but so would these platforms, internet platforms. Now, what if those private corporations said, well, we don't like what Roosevelt's been saying, and we're not going to broadcast his fireside chats. Or in the middle of his fireside chats, we're going to cut it off when he starts talking about something that we don't like. What do you think the attitude would have been on the part of the American people? Forget Roosevelt himself, but on the part of the American people, if that had happened. They would have nationalized the radio, seized the stations. So I'm very surprised that Trump didn't do something along that line, that he didn't come forward and say, well, I have an executive order here that talks about the commandeering of all communication systems in the United States. Not something he wrote. It goes back to various statutes, I think going back all the way to Eisenhower, because they were worried about what would happen in a nuclear war and so forth.
Mm-hmm.
But that's there. Why he didn't simply come out and say, well, I'm commandeering these for the use of these government Twitter accounts. That's too bad for you. Why didn't he immediately start an antitrust action against those people? They all colluded. Hard to believe that there isn't an argument under the antitrust law, the German antitrust law. Contract combination of conspiracy and restraint of trade. Right? They're involved in trade. Talk about themselves as private corporations. Well, antitrust action, maybe. All sorts of things could be done. He did nothing. So there's another example of the impotence of the government. He's there as the president. He has all sorts of forms through which he can operate to deal with some of these problems. And what does he do? Substantively? Well, basically nothing. He just fumes, huffs and puffs. So where are we? As I said before, we're in a state of basically lawlessness, substantively speaking. Now, what can the average person do? Well, I guess he has to prepare himself or the family for periods of economic stringency. You may see more of these phony lockdown operations conducted. Talk about survivalists.
Preppers.
Have food, have water, medicine, adequate supply. If you can do it, an adequate supply of fuel for your car, your truck, or whatever it is, because you may discover that those things are cut off as well. We go back to a Carter-type gas crisis. I remember that personally. People lining up for miles and in front of a gas station to try and be there for the next shipment of gas that would come in. So that kind of preparation. You can imagine, this what I call medical hysteria that the governments at various levels have been putting out since the beginning of last year, and we're bound to see more of that now. Mainly because they've seen they can get away with it. And then the question becomes, at that stage, well, where do you go with it? There's no point going to the legislatures. They're not going to do anything. That was proven with this COVID-19 lockdown business in a number of states. The governor said, we're going to do this. The legislature said, you can't. The governor said, go to hell. We're going to do it anyway. Nothing happened. Court case here and there that limited the ability of the governors to engage in lockdowns. We didn't strike it all down. So what do? You can't go to the governors because they'll be the acting parties. You can't go to the legislatures because you'll discover that they're impotent. Sometimes you can go to the courts, but maybe not on a regular basis, get the whole thing thrown out. And so you're going to be subject to all kinds of basically tyrannical edicts coming forward. And they'll be coming out of Washington, D.C. as well, not just out of the state governments, because they've seen they can get away with it. This is the essence of, tyrants don't suddenly appear full-blown in world history. Well, maybe Sulla. I mean, you can think of a few from the Roman republics or whatever, Roman history. But tyranny usually works its way up step by step because they're always looking for what kind of reaction will I get from the people who I'm trying to tyrannize. And I don't get an interaction from them, I'll take the next step. And I'll take the next step until I'm confronted with some kind of resistance. And in our system, the federal system and divided powers and so forth, the resistance is supposed to come from within the governmental structure. So when the legislature gets out of line, or the executive, then the executive may do something, say veto legislation that's enacted. Or if the executive and the legislature get out of line, the courts will step in and declare statute or executive action unconstitutional. Or if the courts get too far out of line, then maybe the legislature will impeach the justices, so forth. You have all these checks and balances in the system. Well, what happens when the checks and balances all fail? And not fail in form, they're still there in form, but they fail in substance because the particular people who are there supposedly exercising those checks and balances refuse, fail, neglect, whatever, to do it for one reason or another. Well, then the road is completely open to a long train of abuses and usurpations, right, leading to absolute despotism. I think that's the language of the Declaration of Independence. If none of those checks, and that was, if you read the Declaration of Independence and other documents that came out of the Continental Congress about the same time, that's what they were saying. We tried to use the system of checks and balances within the British, quote-unquote, Constitution, this very loose structure that Britain had. Right? We petitioned the king. We tried to talk to his ministers. We even talked to the British people and asked them to try to understand our position. This is the colonists speaking. And we were rebuffed at every point. And therefore, certain other consequences now come into play. But in a sense, that's what you're facing. Here are all these mechanisms which are supposed to protect the average Joe. And what we've seen here in a critical situation, because the election of the president is obviously a critical situation. We're not talking about some zoning decision made in a rural town. In this critical situation, all of the checks and balances have failed. And the people who are now going to be in control, apparently, the Democratic Party and the Harris-Biden administration, they're telling us that anyone who criticizes this is somehow a bad actor. And their allies in the social tech world and the corporate world are telling us that you're not going to be allowed to speak, at least on these various platforms. We're going to shut you down, notwithstanding these are public fora, which was set up for the purpose of having potentially everyone in the community able to communicate with everyone else in the various ways, Facebook, Twitter, what have you. We're going to shut out a large proportion of the population. How many people voted for Trump? 75 million, something like that. Potentially 75 million people who might question the legitimacy of this election are now told, no, you won't, because you won't have a platform on which to do it. And, of course, we're not going to see the Harris-Biden administration applying the antitrust laws to these platforms. We're not going to see them applying the FCC regulations or changing the FCC regulations with respect to these platforms. We're not going to see them, potentially in the courts at least, allowing people to sue these platforms. The platforms all claim, well, this is our terms of service. Contracts of adhesion is what they actually are. They should all be thrown out, because not only does no one understand them, but they are so arbitrary that they can be interpreted in any way that the platforms want to interpret them. So they can't possibly be enforceable. But I doubt that the courts are going to say that. So now you have control over public information and the ability of people to obtain information, share information, which is not only a freedom of speech problem, but it's a freedom of petition problem, because you can't really petition your government at whatever level unless you have some idea of what it is you want the government to do. And that usually comes back to some grievance that you have, or some idea you have for improvement of the system. Maybe it's not a grievance, it's a positive idea. And where do you get the information to determine at that level whether you have a grievance, whether that grievance is legitimate, how it should be handled, whether some improvement is necessary or advisable, and how that should be done? Well, you get that by sharing information with other members of the public. We're not talking about universal genius, a single individual who figures this out all on his own. Right? People get together, and that's why the Constitution, First Amendment, talks about the right of people to assemble for the purpose of petitioning their government. Get together, talk among yourselves, figure out what your grievances or ideas are, and then petition the government to have the government take action. Well, that can't be done if the major sources of information and the major mechanisms for sharing information, debating, discussing, whatever word you want to use, are now going to be absolutely controlled by people with one ideological frame of mind. So you look at that and you say, well, this is absolutely contrary to the principle of the First Amendment. It's absolutely contrary to the principle of quote-unquote democracy, which is supposed to run on the basis of an informed electorate. Right? You don't have morons voting who don't know what's going on or even who the candidates are. You have an informed electorate. Where do these people become informed? They become informed through the social process which disseminates information. And then that goes back to the instrumentalities that are used in that. Well, at one time, it was newspapers.
Mm-hmm.
And you had a much greater choice with newspapers because you didn't like the New York Times. You could always buy the Boston Herald or the Chicago Tribune or whatever. Well, now, because of the way big tech has operated, you're extraordinarily limited. And what they've shown us is, with this parlor business, that's the alternative to what? Is that the alternative to Twitter, I guess? Attempted alternative to Twitter?
Right.
When the competition comes out, when the Boston Herald starts being sold at the kiosks in New York, the New York newspapers get together and require those kiosks not to accept the Boston Herald. Now, if that had happened in the newspaper era, what would people have said immediately? They would have been up in arms. Now, this thing is not simply a matter that Twitter and Facebook and YouTube have their own, Google has its own ideological slant, and therefore what they give you is being censored. But they're attempting to censor other operators.
Mm-hmm.
And it's not just the platforms themselves. It's apparently with Parler, it's the server companies.
Yep.
Right? And it's some of the big corporations that are doing this now. So what we see is an attack by self-styled elitists on everyone else in the country. They're going to tell you what to think, they're going to tell you what to do, and they're going to prevent you from obtaining or sharing information contrary to what they want you to believe, or at least to say or not say. And we know, I mean, I guess the linguistic scientists will tell you, that what you believe is to a large extent based upon what you hear and what you can allow to say. If you don't develop beliefs in a vacuum because they spring up in your mind, like Minerva from the forehead of Jove, right? It's something that's coming into your head, and that generates beliefs, or supports beliefs, or creates beliefs, or whatever word you want to use. So what they're doing here is not only controlling speech, they're controlling belief. Now, there's a famous case, lawyers, again, famous lawyers, Cantwell versus Connecticut, where the Supreme Court comes out and says, freedom of belief is absolute under the First Amendment. I like that word, absolute. You cannot tell someone what to believe. You cannot set up a system that causes him to have beliefs that he would not otherwise have, forces him to reject the beliefs that he has and to accept other beliefs. And that's what they're doing. And the government, which is supposed to be protecting us here, is doing nothing, although they have a whole batch of tools, from the antitrust laws to actual commandeering of these social platforms. Done nothing. And that's done nothing by whom? It's done nothing by the Trump administration, which is the target of this. Let's face it. When the Harris-Biden administration comes in, the government will surely do nothing. In fact, they'll applaud everything that's being done.
Or go even the other direction and say you need to be indoctrinated, you need to be corrected, you need to have your attitude adjusted.
Well, that's what this really is. This is attitude adjustment, right? I mean, you create a world for someone in which the only information is the information that's being fed by the programmers. And you may have had an attitude contrary to that information in the distant past, but you're now bombarded constantly with this other line, party line, and there are all sorts of negatives involved too. Number one, you don't have an ability to say the opposite. If you do say the opposite, say in a personal setting to someone who's also being indoctrinated, they turn on you, right? Because you're an oddball.
Mm-hmm.
You're not going with the program, as it were. You're expressing views that are contrary to, the accepted line. Very difficult for people to fight that, I'll tell you for sure. Once you have a party line functioning, wasn't that the point of 1984?
Mm-hmm.
You had all these structures that prevented you, and therefore you didn't know who to talk to, and if you talk to somebody, they turn on you right away and report you to the thought police. Well, the thought police aren't necessarily governmental entities. Thought police could be your neighbors, people at work, right, who treat you in a different way because you have the wrong attitude. So here we have we've gone that. The point is we've gone that full step. The government has failed. These structures have been set up to control thought and belief, and apparently there's no way that the government is going to control them. And then the average person has no recourse. He has no recourse because he can't get into the public debate at any large scale because things like Parler, not that I'm a proponent of Parler, but an alternative to Twitter and Facebook are being suppressed, destroyed, in this case, destroyed. They didn't suppress the development of it. The thing developed, and then they destroyed it. Okay? The government's going to do nothing about that, although they should. That's another famous case, Marsh versus Alabama. It involved a company town. And this was in the days when coal companies and mining companies,
sure,
they set up their own town.
Industrialists,
for their workers. And the workers would have stores and so forth and homes that would be supplied. And it was really a way to control the workers and keep unions out, among other things, but to control the workers. Well, in this case, there was a company town, and it had like a public square and streets on it. It looked like a regular town. And the question was whether the company could control the speech of the residents of this town because they were employees of the company, and the town was a company town. It was a private operation. It wasn't a regular municipality. Case goes all the way to Supreme Court. The Speaker said, well, what you've done here is you created the equivalent of a regular town. And you created the equivalent of a public square. And therefore, you're not going to be allowed to prevent these people from exercising those rights. Well, that's what we have here. They've created electronically the equivalent of several public fora. And so one would hope that you get a court case that would follow the Marsh versus Alabama line. This is worse than Marsh versus Alabama. Really. I don't expect that to happen either. So now what are people going to do? Well, I guess you're going to have to hunker down and, in a sense, maybe the word isn't resist. It's non-compliance to the extent that non-compliance can be done within the boundaries of the law. Get off Twitter. Get off Facebook. These corporations that are financing this, don't use them if you don't have to. Right? Why does someone have to use American Express? I'll just use that as an example, and maybe I guess there's one of them that's, supporting some of this activity, or whatever company it would be. Why do you have to use that credit card? Get another one. All sorts of possibilities here. The famous boycott. That's the famous hardware case, NAACP versus whichever hardware company it was. This was an action the NAACP took during the days of segregation, which was another example of where the legal system was broken down. There are plenty of reasons to say why the kind of segregation that was being enforced in these southern towns was unconstitutional or even statutorily illegal. Mm-hmm. But the local officials weren't going along with that. So NAACP organized Clayton Hardware. NAACP organizes a boycott of Clayton Hardware Company. And Clayton Hardware sued them. Now, you can't do that. You're interfering with our business. And goes to Supreme Court. Supreme Court says, well, of course they can do it. Didn't involve violence, didn't involve anything that was illegal. They just advocated that people boycott this business. So there's a tremendous possibility for that in this country. Boycotts of one kind or another. Non-compliance with the party. Stop giving them money. Especially the Republican Party. The Republican Party's obviously failed its members. And people need to sit down in a sense and write out a list of, well, here's the ways that I don't have to participate in this system. I don't have to give it support, financial or personal support. And I'm going to stop doing it. And then I'm going to organize my own life so that I can deal with the possibilities of continued breakdowns, lockdowns, whatever you want to call it. I mean, they're talking in places like England, lockdowns of weeks that they're threatening to come up with. Well, what would that do to the economy here? And then, of course, you have the problem of exactly that. When the economy breaks down, what are people going to do who have no income? Well, that's petitioning the government. All right. What is the government going to do to deal with this problem? So you need to organize people for that purpose. And then we get back to the circle again. That's going to be made more difficult because social platforms are not going to allow you to say certain things as soon as they find it. As soon as their algorithms find the bad words, then they're going to shut you down.
Yeah.
So you have to look for alternatives there. And maybe the alternative there is, I don't know, an internet, something like Zoom, where you hold conferences or conference calls on the telephone. There's no way they can shut the telephone down that way because of the content of conversations. At least I haven't heard them claim that they have an authority.
So many people now use cellular phones, which actually all do run through servers and everything like that. It's not just like
then you got a
wired
problem.
Phones. Yeah.
That's right. Then you got a problem. Then you got a problem. Then you've got to get something in your home besides a cellular phone. And use that one. All right. Begin thinking about this. Because what is the alternative? Well, the alternative is they're going to clamp down more and more and more, certainly in the social platform area, and narrow and narrow and narrow the range of acceptable discourse. And then exactly what do you do? If that's the only method that you have, the only methodology, the only instrumentality that you have for communicating those ideas to others, well, then you've been boxed in. You've been essentially eliminated as a political figure, political actor. And that comes back to, they're all screaming about democracy. This is what I find amazing. Right? Some of these people say, well, you're not allowed to challenge this because that would upset our democracy. Well, wait a minute, democracy is based upon true votes, not false votes.
Right.
You beg the question when you say you're interfering with democracy by asking whether the vote was true.
Right. Yeah. There's that lot of terminology about that, interfering or undermining the public confidence in our system.
They've already done that beyond reparation. All right. I can't believe that any intelligent person, IQ above the wattage on a light bulb, and I'm talking about an average light bulb, 60 or 75, has any confidence in this system anymore. And I'm talking about Democrats, Republicans, anyone else. The Democrats can be gloating because they won, but they realize how they won. The Republicans are on the other side. They're in despondency, realizing what happened. But I don't believe there's anyone, any honest person in this country, who can stand up and say, I have confidence in the integrity of our electoral process and our democracy. That person, I think, would really be a candidate for psychiatric evaluation. It's impossible to look at this and say, I have confidence. Not to mention the fact that, of course, this is not a democracy. I mean, how many times have I heard that? It's not a democracy. It's something quite different. And especially in the presidential election, it is definitely not a democracy. It happens to have been set up that way instrumentally because, let's say, legislatures have put in plebiscites as a means for choosing electors, but that has precisely nothing to do with the real structure of that system. So people who are looking at this and saying we shouldn't undermine the confidence in our democracy, although the exercise of quote-unquote democracy undermine the constitutional structure of the selection of the president. Forget just the fraudulence of the elections, but the whole damn structure has been undermined. Well, those are people, I mean, there may be some people who are so hopelessly ignorant of how this system is supposed to work that they might believe what they hear on MSNBC or one of these other outlets. But the reality is, I can't believe that any intelligent person could stand up and say, oh yeah, I have perfect confidence in the integrity and efficiency and whatever of our electoral system. It's nonsense.
Our founding fathers faced a lot of the parallel problems you've described, but they had an ocean between them and Britain, and they had closer to parity of weaponry, that sort of thing. This completely engulfing digital age that we live in seems to put us maybe on new ground as far as how ordinary people who love freedom and love the founding of our country can stand up and restore the freedom for their family and a future for their children. We'll have to have you back on again to talk to us. You've given us lots of food for thought in terms of both where the pain and the injury has occurred, what our grievances are, and the failed remedies, and then some practical tips on things people can do that they still have power to do. You haven't used the reference, as you often do, to state militia yet in the founding of our country. So we'll want to circle back with you on that, and ask in the future what we can do. So we may have to have you on more often these days with these things going in fast forward. But we're just extremely grateful for your joining us again. Any parting thought for our audience?
Well, I guess the basic parting thought is not to become despondent. I mean, people look in a very short-term way, and they say, "Oh, there's nothing we can do." Well, that's certainly not true. There's always something you can do. It's just a matter of sitting down. I remember let me give you this one quote. This happened during the 1940. The Germans had broken through and outflanked the Maginot Line and basically trapped the major French and British forces up in northeast France and Belgium. And General Dumenque is presented with this information when some aides come in and say, "Oh, this terrible thing has happened." And he responded, he said, "Every war has its routes. Let us look at the map and see what can be done." And that's the message I would leave to people. Yeah, every political conflict in world history has those periods in which one side prevails apparently to the nth degree and the other side loses everything. And the short answer is, well, that lasts for a while and then things change, right? Because the losing side begins to make the right decisions and the winning side begins to make the wrong ones, and so forth and so on. So let us look at the map and see what can be done. That's my parting shot.
Thank you very much. We've been speaking with Dr. Edwin Vieira, frequent contributor on newswithviews.com. Dr. Vieira, if people want to find your writing, they go to newswithviews.com?
Yeah, sure. They can find most of my internet stuff there.
And folks, if you want to not lose touch with us, depending on how long we're able to stay on this platform, make sure you go to libertyandfinance.com. Sign up for our free newsletter so we can stay in touch with you. You'll see all the details of all our interviews and links to our new postings that we're making to alternative platforms as we're trying to diversify that so that we can make sure we continue to be able to speak freely. Dr. Vieira, as always, thank you for joining us here on Liberty and Finance.
Okay, thank you.
If you've decided that now is the right time for you to protect your family's financial future by acquiring physical precious metals, gold and silver, I'm delighted to let you know that I have now become a licensed dealer's representative for Miles Franklin, one of the oldest and most trusted names in bullion dealerships. And we can provide you with physical delivery to your personal possession or to professional vault storage or precious metals IRAs. Just email me at libertyandfinance@protonmail.com, and please include your name and phone number in your email to libertyandfinance@protonmail.com. We'll get right back with you and find out how to best meet your needs so that you can either begin or increase your acquisition of physical precious metals now and protect your family's future starting today.